Welcome, everyone. Wow, we have a great turnout today. We're so happy that you have taken the time to meet with us today. I'm sure you want to jump in and learn about these recent changes impacting most businesses. We ask that if you have any questions to enter them in the Q&A section. I know we have a lot of content to cover in a short period of time. We will try to get to as many of your questions as possible. We do have upcoming webinars where we will break out some of the challenges, where we will break out some of the changes into more details. So please keep an eye out for those in the upcoming webinars. Just so you're aware, we have muted everyone and request that there not be any AI recordings used for this meeting. And we appreciate you taking the time out of your busy day to join us with this information-packed presentation. With that, I'll turn it over to Taylor.
Awesome. Well, thank you very much. And like Nancy said, we appreciate you all for being here today. The goal of today is just to go over, there's been a lot of law changes and things that we just want to make sure that everyone knows about. And we're coming to today because we have a passion for small businesses, and we want to make sure that you know about this information and that you know that you have someone to come to as well. My name is Taylor St. Clair, and I'm going to be going through the slide deck for you today. Like Nancy said, enter any questions as we go in the Q&A. We're going to aim to get to as many of those as we possibly can. I am the Director of Operations here at HR Partners, and we have been in business for 25 years, coming to you out of Atlanta. So I'm going to go ahead and dive in. I will turn my video off and we'll roll. All right, and so to start, we have essentially we're going over best practices today. So things that we want you to know about, things that you can proactively do to make sure that you're aware of everything going on and managing and maneuvering around these properly. So some of those things, there's a new law about 1099s. We're going over FLSA and how to classify your W-2 employees. There's a new walk-around rule that could affect OSHA, and then we have pregnancy and accommodation laws. We're just going to touch on some federal and state laws, documentation and security, and again, just those proactive measures that we recommend that you take to make sure that you're taken care of. And so first, we're going over the 1099 classification. And so that started actually March 11th. So all of these are kind of new things coming at you. But essentially the laws now are more comprehensive for 1099s than you have seen in the past. Some of the hoops that you have to jump through are similar. However, there were core factors before that you had to look at, and two things were more important than the total. But now we have to look at a total of 6 things. They're all weighted evenly. And so we want to make sure that we're looking at these in the correct manner. So we're coming at you. And then also with any state laws, I think it's definitely in California and Minnesota, I believe, that follow the ABC rule, which can even be more stringent than what you're going to see here. So definitely make sure to keep in mind those state laws if they are going to be more complicated than what we're going over today, because it's just going to be the federal laws. And then misclassifications can be costly to the organization. So there would be, fees involved and things like that. So just if someone is classified as a 1099, now does not mean that they're still a qualified 1099 under the new rules. So definitely something that we just want to look back on, make our little checklist and double check with everyone. You can also go to the DOL website if you have questions. They have a number you can reach out to. You can ask us, if you have any questions as well. But there are ways to kind of double check this information as you go. And so the factors are, as you see here, so there's 6 again. So we have the opportunity for profit or loss, and then the and that was one of like the core factors before. So now everything again is just weighted the same. So we're going to look at their opportunity for profit or loss. So that means, are they able to negotiate their price for services or goods? The relative amount of investment made by the worker and the employer. So who bought the tools that are being used? You know, are you providing them with the tools to get the job done? That would indeed imply a W-2 situation instead of 1099, because generally a 1099 would come in with their own equipment because they're running their own business. And then the permanency of the relationship as well. So that's going to have to do with, hey, is there an end date on this relationship that we're coming into? Or is it project based? Or is it, hey, I need you for 3 months? So that's certainly something to consider. The nature and degree to the potential employer's control. So this is going to be where, are you directing the actual work that the worker is doing? So we want to make sure that 1099s, you know, they come in with their own equipment, you tell them what you need done, and they may be doing it at 2, 3, 4, 5 in the morning. But that doesn't matter to me, right? Because the job is getting done at the end of the day. So we want to just make sure we're considering that as, where do they get their direction from? The extent to which the work is performed as well. And it just, if it's, you know, part of their actual business, and whether they use specialized skills. So it's really just making sure that we have those skills and that they're using those as they are marketing to other companies as well. Because we want to make sure that as a 1099 relationship that you're marketing to other people, that they don't work for just you, because that can be kind of a sticky situation. And we have this infographic that's just straight from the DOL. And so this is going to be, you know, indicators of an employee on the left, indicators of an independent contractor on the right. And, you know, so like as an employee, you'll be able to, you can only earn more if you work more hours, right? But then on the independent contractor side, well, you can increase your profit through business decisions and just say, hey, my price for XYZ went up, and that's kind of the fact. You know, and then we have the temporary relationship until the project is completed as well. So that goes along with how long we're agreeing that this relationship will last. And then we're deciding on which projects they'll take on as well. So that definitely gives on the 1099 relationships, and hey, yes, I can do this for you, or no, I can't, where an employee can, you know, is kind of, hey, this is your job to do this. And so that's the main thing for the 1099 laws, is just that it's more stringent. Again, this is at the dol.gov. You can look into these. I like this infographic a lot. Just because it kind of checks them down, and you can ask yourselves these questions, and you pretty much know the answer to these, right, by getting around the jargon that may be used. And then another big one that's going to affect a lot of businesses, and this is regardless of your industry, this is absolutely a very big one that we're going to be looking at, and you'll see that there's a couple of dates here. One is going to be July 1st, which is coming up, and then January 1st of 2025 is when the real kind of the final shoe falls. So when we're classifying our W-2 employees, you know, we're writing out offer letters, we let them know ahead of time if you're going to be an exempt employee or if you are going to be a non-exempt employee. And so in order to be exempt, you have to pass, you know, the duties test for, you know, there's administrative, there's executive. So you have to make sure that you are either a supervisor over employees, or you have some level of autonomy to make your own decisions. So that's the duties part of the test. You know, there's definitely more to the duties test itself. But the other option was that I think it was 30, yeah, it was 568 initially. So if you made at least 35,000, then you could be exempt. However, these numbers are changing now. And so what that means is that now we're looking at $43,888 as of July 1st. But really, we want to look ahead. We want to make sure that we're planning, because January 1, 2025, believe it or not, is going to get here sooner than you think. And so we want to make sure that we have this on the radar, because now if we're looking at our employee list and we have individuals that are exempt right now, exempt meaning that their salary, their check looks the same. We don't have to think about overtime for these individuals right now. This kind of just, that payroll is just running. But now we need to go back and determine, for instance, if I have someone who's exempt right now and they're making $45,000 a year, right? So they pass the duties, they have, you know, that general, they may be a supervisor in the field, and they're making $45,000 a year. Well, then now we need to look at that employee and say, hey, are we going to go ahead and meet this threshold and let them keep that exempt status and pay them $58,656 a year? Or are we going to keep their pay the same and then make them a non-exempt employee? And so when we're thinking about, you know, these changes, it's really going to have to do with where you are as a business. And this is certainly something that is affecting small businesses, you know, all the way up. And we're going to have to look at these and pretty much on a case-by-case basis, because you're wondering kind of how much overtime would they get, right? Where is it going to flesh out for me, for my specific situation, you know, as a business owner, or whoever may be, you know, making those decisions. And so we just want to make sure, especially if they're going from exempt to non-exempt, you know, that means that then they're going to have to start logging their hours. And so you want to make sure, you know, while I mentioned those salary employees, hey, that's going to be quick, just runs right through payroll. But now we're talking about timekeeping, and we're going to say, hey, we know that you've never had to log your hours before, but now when you come in for the day, you're going to have to clock in, you're going to have to clock out for your lunch, you're going to have to clock back in, you know, so it will also be some change management to make sure that you're following up, that these rules are being changed, and that everyone's kind of keeping up with the what and following through. And then next we have the walk around rules. And so these are changed, and it's mostly the rule seems rather benign on the face, but I think this is mostly kind of talking about the interpretations and things that the rule now allows that it did not before. So again, this is going to be for kind of certain industries, but as of May 31st, OSHA's new walk around rule will allow employees and the employer to authorize a representative to accompany the OSHA compliance officer during an inspection. And this representative does not have to be an employee of the company, but they do have to be reasonably necessary, right? So something that kind of makes sense for this walk around, saying, hey, we're going to have this person go with you. This is why they really know about X, Y, and Z. There aren't many details on what would cause someone to be qualified or found as reasonably necessary. So again, this is all kind of nebulous, but I think the biggest implications are that this opens doors to a union representative to be that person if they were so elected, and even if they are not you know, an actual employee of the company. So that's more just kind of letting you know those implications, making sure that if we are electing someone to walk around with our OSHA compliance officer, that we know who that is. and that we're checking on that regularly, because now this is a possibility, but you'll have a say. It's on your site. So just wanting to check in on that one. And the next one is going to be a big one. This one is the Pregnant Workers Fairness Act. So this is going to change the way that we generally do a lot of business, because we're already familiar with so many laws that we kind of have to work around. Well, not work around, but work within, especially on this federal level. There's things that you have to be aware of with certain thresholds and essentially case law that you need to be aware of. And this is going to be something that's going to be right up there with Title VII, ADA, FMLA, things you're going to be hearing about it. So this is the PWFA, is going to be the acronym. And so it goes into effect in June. And the bottom line is going to be that this requires employers with 15 employees or more to make accommodations if someone requests, if that request is in relation to pregnancy, childbirth, or related medical conditions. And those conditions are going to be wide-ranging at the end of the day. And there's going to be a comprehensive list, and there's pages and pages long. But essentially, it'll cover things like lactation as well. And actually in Georgia, we were a progressive state. We passed a pregnancy act that included lactation breaks that needed to be paid for. So there are going to be some of those state laws too that still, keep in mind with this, but this is going to be a federal one to kind of run in tandem with those laws that may be passed in your particular state. And so you'll have to make these accommodations, and a reasonable accommodation is just a change in the work environment or the way that things are usually done at work. Generally, the burden is going to be on the employee to raise the need for an accommodation, and then the employer must respond. So an employer is not expected to know without being told, to what degree the impairment or impact on your job is. Unless there's an actual disability involved. So, if that this employee has a disability for any reason, because it could be obvious if someone's, in a wheelchair or something. So there are instances where you kind of should have known. But generally, we are waiting for the employee to come and say, hey, I need an accommodation, and is due to, pregnancy. And again, we'll go over the exhaustive list. And so this was brought forward by the EEOC, and I put this here in the slide to make sure that you are all aware of kind of how this is being presented to the employees. So you'll see that the EEOC, this is kind of a poster that I cut in half, but it says at the top, if your pregnancy, your childbirth, or your related medical condition makes it harder for you to perform your job, you can ask for a change called a reasonable accommodation. And then it goes into these steps here. And so 1, talk to your employer, your manager, your HR representative, or person designated. And explain that because of a mental or physical condition related to these items, you need an accommodation. And then you'll see there, it says that covered employers must provide a reasonable accommodation unless it will cause them an undue hardship. And then it says, share with your employer what barriers you're facing, give ideas if you have them for what could help you do your job. So we want them to come forward, and we want them to give us an example. So we want to definitely hear them out. Because also here you see number 4, it says if your employer says no, then provide this information and tell them to go to the EEOC's webpage. And so this is where I'm getting a lot of, the information from today's slides. This is a long website. There's a lot of expansive information here. So something to familiarize yourself with, but also make sure that, we wanted to make sure that you are aware of how this is being communicated to your employees. at the end of the day. So we'll go into these conversations and kind of how to have them as well. But again, this is something that's, you know, coming down from the EEOC. This is something that is very, very new. And so defining pregnancy, childbirth, and related medical conditions. So that could be in relation to current pregnancy, past pregnancy, potential pregnancy, lactation, use of contraception, menstruation, infertility and fertility treatments, endometriosis, miscarriage, stillbirth, having or choosing not to have an abortion, and then many other conditions. And so that related just means, you know, that, you know, new physical and new mental conditions that could arise because of, you know, pregnancy, and then pre-existing conditions that are maybe exacerbated by it. So you'll see that this is again, a very extensive list. We can, you know, follow up after this with an extensive list for you. But, you know, some examples, the EEOC lists, you know, migraines, morning sickness, appointments, and then the contraception is going to be like if you're getting an IUD put in, any recovery time or complications that comes from that. Menstruation, you know, on an extreme level is going to be endometriosis. And then, you know, and some of these are arguably borderline going to be FMLA too. So these are things that kind of play with each other. But again, FMLA is 50 employees or up. This law is if you have 15 employees or more. So this is going to affect a wider range and something to think about. And then, of course, like with the appointments, that's like IVF appointments, and kind of just trying to tie these in together and give you all some examples, because again, it is a very broad subject matter. The main thing about these limitations is that they need to be temporary in nature. So if we're expected to make these accommodations, right, then we need to know that, hey, I can make this accommodation, you know, because we're assuming that sometime in the near future, they will be able to rubber band back to, you know, how the normal ebb and flow is working now. And you'll see in the near future is in quotes on this slide, and that is because there is no defined time frame. So, you know, we all know that an average pregnancy is 9 months, but there is no commitment to any kind of time frame for this. There's no way, and again, this is such a new law. There's not a lot of case law, you know, there right now. So it's kind of we don't even want to put a number on it because we don't know. But it does have to be temporary in nature. And so if this is a permanent, you know, condition, then that's kind of where the line would be, hey, this is ADA. And then if they're not eligible for FMLA or state leaves as well, then we just want to approach this, you know, straight up as an accommodation issue, because this is going to be subject to the greater rights law. So if there are state leaves with richer, you know, rights allowed or anything like that, these can run in tandem. So we just want to make sure that we're always applying the greater rights when we're looking at these situations and taking into account what state we're in or what state the employee may be in, if that's different. And then, of course, if leave is found, you know, to be the accommodation at the end of the day, then they still have that job protection there. So that's kind of one similarity that it has with the FMLA. And then we have the reasonable accommodations, you know, and again, like that poster said, it has to be made unless it would cause an undue hardship. And like I mentioned, a leave does qualify as an accommodation under the PWFA. However, we want you to be careful. We want you to be careful with choosing this as a blanket option. Because this is kind of a last ditch effort. If there were no other reasonable accommodations that you could find or, work with the employee in question to make work. Because this is actually one of the stated purposes of the law. So the reasoning behind this is that, hey, if someone, is pregnant, they're actually, they want to stop people from being forced to go on leave early. When there was a possibility that an accommodation could have been made to keep these employers at work. So yeah, please keep in mind that that is the purpose of this law. While a leave does qualify, we just urge you to move forward with caution. And then the other cautionary tale is just going to be if you want to claim undue hardship, we recommend speaking with a labor attorney. Because at the end of the day, this is going to be something that is the burden of proof is on the employer. So if you say, hey, it's going to be an undue hardship, I can't make an accommodation. Well, one, we're gonna need to document that one a lot. And we want to make sure that that we've considered all of the options. The definition of an undue hardship in this case is very similar to the ADA definition. But then, I think under the ADA, like an elimination of an essential function is not reasonable, but in this case it is, as far as making accommodations, even if it's one of those essential functions of the job, then we're definitely still gonna have to look at that, see if we can suspend it, see if we can move it around. But the undue hardship definition is still based on just, hey, it's difficult, and then if there's a large expense involved. But again, just want to recommend speaking with a labor attorney, especially with the law being so new, then we want to consider, make sure that we're considering all of our options. And we have some sample accommodations here, just to kind of get you thinking. A lot of some of these, I think the first three that you'll see here, they're from the EEOC website. And it's because pretty much these are the most common ones. So just don't even think before you give these out, pretty much. Because the EEOC has stated that they're a given and they cannot cause undue hardship to your company. So we don't want to say, hey, I don't know, I can't let her sit at the front desk. So I'm going to call that an undue hardship. That's just not going to happen in these cases. So definitely think of these kind of as your go-to. Absolutely do it. Don't give it any extra thought. And if there's, because we're also thinking about this, that there's no case law on this yet, and we don't want to be the first one, my friends. And so just, there's other options here, of course, that, might be able to make work. Light duty, if that's something that you regularly offer, or if that's something that you think you could document for that position. Schedule adjustments, so that's going to be kind of like the morning sickness, like, hey, every time, every single morning is morning sickness that I'm struggling with. Can I come in at 9 instead of 8 in the mornings? I think that would help me. Remote work. And then we have temporary reassignment and suspension of duties. So this is what I was talking about as far as the essential functions. Even if some of the essential functions of the job are affected, we need to make sure that we're considering, moving this around, temporary reassignment, suspension of duties, or transfer at the end of the day to a vacant position. Only transfer though, if you can't accommodate, their current position. Do not create a new position, or you're not obligated to promote them or anything like that. One key thing to think about as well while we're looking at these, and I know I kind of glossed over remote work, But the first thing that, you know, a lawyer is going to look at a case is the measures that you took during COVID. So definitely something to think about, as that can kind of be a precedent that you set, saying that, hey, you know, they did this job during the COVID pandemic remotely, but now you're saying you can't make the accommodation to allow them to work remotely for this temporary period of time. So that's kind of the implications, and just looking ahead as far as forecasting and what we're expecting. And we, you know, always work with labor attorneys. We love Fisher Phillips as well. So just want to make sure that, to kind of give you that insight and understand that look back could be setting a precedent. And then, you know, we have the interactive process. And so the interactive process is just when that employee comes to you and says, hey, I need an accommodation. What we recommend is to say, all right, well, what were you thinking? That's kind of where you start. What were you thinking? So because there are instances where it's unreasonable to ask for too much, you can ask for documentation when it is reasonable, meaning that, hey, like, the pregnancy is obvious, right? If someone's there, you can't ask why they need the accommodation, or ask them for a document from their physician if they self-confirm. They come to you, they say, hey, I am pregnant and I need, you know, to have my water bottle with me at all points in time, and I might need some extra breaks during the day. So that's kind of the okay if they self-confirm. If the ask is more obscure, you can ask for documentation only if it confirms the condition that is not obvious. It confirms that it is related to pregnancy, childbirth, or related, like the, you know, overview of this law. And if it describes the adjustment or change needed specifically. So always important to just remember this, and don't ever ask for a doctor's notice if you wouldn't under normal circumstances. You know, for instance, if they miss one day, but you wouldn't ask, you know, it's in your handbook policy that, hey, if you miss 3 days, we're going to ask for a doctor's note after that. But then don't ask for a doctor's note if they miss 1 day, because you wouldn't do that for other situations. So just want to make sure we're sticking with that consistent policy as well. All right, and then so what can we do? What we recommend is, you know, a written job description, you know, prepare before advertising or interviewing for a job, and then that can be considered as evidence of the essential functions. And then when we're identifying those essential functions, you know, it's whether the position exists, you know, only to perform that one function, the number of employees available to perform it if we have to spread it around, and then the degree of expertise or skill required to perform the function, also how frequently they do this one item, you know, the consequences. Is this something that we can delay for a period of time and then can kind of be caught up later? So lots of things to think about, but the best thing that you can have is that documentation right up front, so you can go down the checklist and say, oh, well, they can still do 8 out of 10 things. All right, I think we can make an accommodation, right? And it'll just help you make a more organized and fully thought out decision. And I know that was a lot, my friends. We're gonna move along. But thank you for going on this ride with me, because it is a big change for sure. Again, that's coming out in June. And then we have non-competes. I think a lot of people heard about this. I think it dropped last week, if I'm not mistaken. But as of August this year, all non-competes will no longer be enforceable. And so that means that you won't be able to enter into a non-compete, and any current non-compete agreements are void. And that stands if they're still your employee now, or if they were your employee and it's still just in that time frame of where it's active. So all of those are void. And you do have to be proactive on this as well, because you're required to let everyone know that they're no longer subject to the non-competes in place. The only exception to this rule is senior executive positions. And we just added in here too, this is certainly being challenged in court. So this is something that, you know, may mold over time, but this doesn't change the fact that we have to be proactive, you know, and we have this August deadline. So definitely something to make sure that you get in order, and go back and look at, you know, know exactly who you have active non-competes with. Because the notice should be clear and conspicuous and identify the person. So we're gonna say, hey, Dave, instead of dear ex-employee. You know, we want to make sure that this is something that's going directly to this person. This must be in digital format or on paper. This cannot be a verbal discussion. And the only way that you're going to be exempt for this is if you have no record of street address, email, or phone number. But we highly recommend sending this out again to those current employees, even if they're not your current employees, but are still within that time frame. So again, develop a plan. This is something that is going to be ongoing, but we want to make sure that we're looking at our strategy. We want to make sure that, you know, in the next few weeks we're going through, we're finding every single one that's active right now. And we want to make sure that we get, you know, our trade secrets in order as well. If we don't have these non-competes, then what are we going to do to pivot, right? What are going to be our alternative options going forward? So we definitely want to make sure that this is something that we're thinking about going forward. And then just a reminder here on the federal laws in general, you know, there's lots of times where you hit a threshold for these different laws that you may be subject to on a federal level. And so state continuation, and we have the Georgia information here, that's going to be variable for every state. And then the Equal Pay Act and OSHA is going to be under 20 employees. And then 15 plus, so these are going to overlap, but that's Title VII, the ADA, GINA, PWFA as well. And so just, and then of course, COBRA, ADA, FMLA, and ACA. With ACA, the coverage must be affordable according to the formula, or you could face penalties. You know, there's big penalties for all these, especially, you know, the ones the EEOC are involved in. In 2023, just over the year, the EEOC received more than 81,000 new discrimination charges and obtained $440 million for victims of employment discrimination. You know, and this PWFA law that just came out as well, they said they're focusing on it for the next 4 years. Like, this is, you know, high on their list to make sure that everyone's pivoting in the correct manner. So these are things, again, that we want to just make sure that are on your radar just in case they weren't, and make sure that you feel that you have someone to ask some questions, because I know that there's a lot to navigate. There's a lot of acronyms on this screen here. And then state laws as well. I think there's just been a little confusion I just want to touch on lightly, is a right to work state versus an at-will state. A right to work just means that you can choose whether or not to be in a union, and you are not required to join if you take that job. So if there's already a union there and you're in a right to work state, that means you can join the union or you can choose not to join the union. And that's the end of the definition for right to work state. And then at will means that, you know, an employer can fire an employee so long as it is legal, or the employee can leave at any point in time. And so I feel that oftentimes these can just kind of be used interchangeably, and just wanted to draw that. And again, thinking about state laws, that, I mean, that slide deck would go on forever, because we have, you know, overtime laws, minimum wage, paid leave, sick leave, timing of the final check is different for every checks, you know, does this state consider PTO earned wages and we have to pay out? You know, the biggest thing kind of going through now is job postings and pay transparency. So you have to make sure that, hey, if this job is open to people to apply from New York, are you posting the salary? And then the non-compete agreements, again, this was made on a federal level, but there are states coming out with their own non-compete laws as well to be aware of. And then just going to go over some quick documentation and security. Just again, these are kind of more of the best practices. So don't lead the employee to provide certain I-9 documents over others when they come in. We want to give them a list and say, please provide appropriate documentation. If someone provides extra documentation, you know, they give you their ID, their social, and a passport. We need them to choose and store only those, because it could come down as discriminatory at the end of the day. And this is like when if they were to do an I-9 audit, then it would say, hey, why did we ask this person to provide more documents than we asked everyone else? So just a bad look. It's not ever really the intent, but something that, you know, to make sure that you're aware of. We also want to make sure that those I-9 documents are always separate from their personnel file. And so that's going to include, you know, and also keep in a separate file, background checks, you know, investigations of claims, medical information, and things of that nature. And then for terminations, the main thing to remember is that if it is not in writing, then it did not happen. If we decided that, you know, it's time for us to cut ways with a particular employee, then we need documentation at the end of the day. Is going to be best practices. Emails are good enough in so many cases. You know, if you have a verbal conversation, all you got to do is turn around when you sit at your desk, send a recap. Hey, just to recap the conversation we just had, we determined A, B, C, D, F, G, right? And so just always think of this as kind of building a case, making sure that you have evidence, understand that worst case scenario, you know, the audience for this later could be judge, jury, agency. And so we want to be prepared. Transition agreements can always offer, you know, some solace to an exiting employee if we go ahead and give them 2 weeks, even if we ask them not to work. And they are create that limitation of liability for the company as well. And then for terminations as well, we also just want to remember that we're turning off those system accesses properly. We should have a running list. Hey, when you come on, you get this. Well, we need to look at, you know, that same list and go from the bottom up and make sure we're turning those accesses off. And then, you know, security is important as well, just when it comes to all of these documentations. We want to think about, you know, all the information that we come into contact with on a regular basis, and are we storing it securely? You know, socials, date of birth, and even like, I think one that gets missed a lot is like sending benefits information. That it should not be sent via an unsecured email. So we want to definitely think about, you know, encryption services, and however, or if you're sending it to someone, they may be able to send you an encrypted email and then you could just reply back. But always give it that second thought before you send someone social, especially that banking information too. That's common scams through your industry. That's one of the most common emails right now is saying, hey, I want to change my banking information, but I can't get to the portal. Can you just change it to this number? No, don't ever do that. We want to make sure that it goes straight through that secure portal. So then that way there's no liability, you know, and there's no even extra thought, because the person, if they did send that email, should appreciate the fact that you're asking them to enter it in a more secure manner as well. And then always make sure that we're not asking for more information than we need. The less information that you collect at the end of the day is the less information that you're responsible for. You know, if there were to be a breach, then you would have to tell everyone who was affected at the end of the day. And no one wants to have to send that email. And then generative AI. Just as far as security, I think the main thing to think about with generative AI is that it builds on itself. It learns from what you tell it. So we want to make sure that we're not putting sensitive company information into ChatGPT and saying, hey, this is my company, this is my strategy for moving forward, here's my employees' information, can you run me any kind of information or survey or something? Because it will store that information, and then maybe when your competitor comes back and is saying, hey, what's everybody paying around me? I want to make sure my pay is competitive. Well, it's in there now, right? And it can give that information. So we always want to just make sure that we're thinking on the sensitive side when using AI, but it is a incredibly useful tool. Please know that it is a time saver for sure. We just want to make sure we're using it correctly. And so, what practices keep me safe? So we went over a lot today, but, a custom handbook with policies in place to clarify expectations is a great place to start. Make sure that you have all of these things in writing. And then on that note, take that handbook and make sure that you are consistent in your policy adherence and you are actually following it on a regular basis. That keeps your liability down if you're, adhering to that policy no matter what. We want to make sure that our managers and people in position of authority are actually trained on, the handbook, make sure that we have that unified front. Of course, background checks and drug screens can always help with, vetting employees, and it depends on where you are. Maybe they're traveling to, individuals' homes. It's always important to know and have that background check information. Drug-free policies can go in your handbook. And here in Georgia, I know you can even get a workers' comp discount if you, have an annual training and sign up for that. So always something to think about that could be in your state as well. And then, of course, as we talked about, those documented job descriptions and with the essential functions defined, documentation, documentation. It's going to be your best friend. Because it's going to be the only way, sometimes it's the only way that individuals will respond, but it is certainly one of the few ways that you can actually note a pattern if a pattern were to develop, right? And also, as always, if unsure, consult with a professional. There's certainly gray areas. A lot of these things are very new. So we want to make sure that, we're consulting with the right people, getting the right advice, and really thinking it through. And my name is Taylor St. Clair, the Director of People Operations again, here at HR Partners. And we want to thank you for being here. We appreciate it. We're going to do a deeper dive into these topics. But just a little bit on who we are as well. We're a full service HR firm. And so we offer PEO solutions, we offer ASO solutions, and HR consulting services as well. The QR code here goes right to our website. So, because we know that if you signed up for this webinar today, the ones that we're mentioning, they're going to be coming down the pipeline later that are going to go a little more in depth. You'll receive that information. But we have a great HRIS system, everything's all in one place. And we're happy to talk with you if you have any, questions coming up, or if you're ready to scale your business, looking to the future and ready to grow.
All right, thank you, Taylor, for that great overview. That was incredible, and so much information in such a short amount of time. I know the HR Partners team will be offering a deeper dive in future webinars coming up, but for now, let's take a couple questions. It looks like we have a lot of questions today. That is really terrific. And if we don't get to your questions, please plan to participate in our future webinars that break down these laws and go into a deeper dive. Or we will try to follow up with you next week. All right, so let's start with the first question. What if someone who has been a 1099 and they want to remain one and they have a signed agreement, but we are their only customer?
Oh, yeah. Well, I think it's, kind of sounded good until that last part, right? So you want to make sure that we're considering, again, every single one of those 6 factors, making sure that they own their own business, making sure that they can control their revenue by them marketing to other businesses that might want something similar. They might charge one price for this size, another, and again, it's just, those penalties that are coming up now. So it is important to make sure that we're not following the status quo, that we're looking at these with fresh eyes based on what just happened.
Thank you. The next question we have is, under the Pregnancy Awareness Act, does this mean that I would have to adjust someone's position if they stated they cannot stand any longer while they are pregnant and they are on an assembly line?
So they can't stand on an assembly line. Is that right?
Yes.
Okay. Yeah, so this is going to be, we want to look at these on a case by case basis, right? So that's the most important thing, is understanding that how new this is, and so we want to look at this and we want to be creative. We want to say, hey, would a taller chair work? Hey, would they be able to work maybe at this end of the assembly line instead of this one? So it just kind of depends. I think the answer is yes. Do I need to, allow them? But we still, of course, especially like when we're thinking about assembly lines, we want to think about safety.
Okay, thank you. Another one for the Pregnancy Awareness Act is, if someone needs to take time off as a part of the accommodation, would that be paid?
No, under the PWFA, you do not have to pay for that. If you do come to decide that leave is going to be the best option for you, however, then that is going to be, make sure that you have that job protection as well. And make sure that you, of course, like if you have PTO or any kind of paid accrued, paid time off accrued, then we could definitely offer that first and say, hey, definitely go ahead and take this. And we would recommend that as well, so that they don't end up taking the double time also.
Okay. And we just have a couple other questions that I think we have time for. If I have employees who are now going to be non-exempt because of this recent change, do I need to have them also enter their time now?
Yeah, sooner rather than later. So there will definitely be, if you want to look at where your current pay period stops and then the next one picks up, and maybe that would be kind of the cleanest way for you to do that. But again, sooner rather than later is all that we want to share about that. And then you want to make sure that your system you're currently using has that timekeeping, that we're transferring it over, that there's no room for error. For instance, our system would flow straight into payroll, because we want to make sure that any changes that would be made to anyone's timekeeping card is only done with their permission. And no one wants that payroll, to come out differently. But just make sure that we're having a candid conversation with the employee as well, and that they fully understand what's expected of them. I hope that answered the full question.
I think so. Thank you. And the last question for today is, does this recent change provide any protections if I don't have childcare?
No, it does not. Like different situations though, right? So maybe if you have childcare, But you have to go and breastfeed that child, and that's, so you have childcare close to your house, you need to go breastfeed and take time to do that and then come back, then that could be a different situation. But certainly there's nothing in the law that says that not having childcare would apply.
Okay, thank you, Taylor. And these are all great questions, and we're sorry that we didn't get to all of them. Again, please look for our future webinars in the next couple of weeks. Also, please visit our website to learn more about us and our incredible team. And just to share a little bit about our company, we have been supporting small to medium-sized businesses and their HR teams for the past 25 years. We leverage technology with a team of experts that wraps around your team to be those extra hands, relieve your stress, and provide a seamless and one-stop solution. We are a full service solution versus a technology or self-service solution. And we really look forward to seeing you at the next webinar. But in the meantime, you are most welcome to reach out to us either by phone or email. And we hope you have a great day.
Thank you all so much.